afternoon, folks. Going to call this session of the BMZA, the February 25th, 2020 session of the BMZA to order. Just a preliminary matter. You see before you there are 4 board members presently. At some point later in the afternoon, probably around 3 o'clock or so, the 5th board member will be added due to a prior commitment, but that doesn't give rise to any different administrative rules that we apply here for 4 board members. As we always ask at the beginning of these proceedings, please turn off your cell phones and keep talking to a minimum. If you do have to have a conversation, which at times we do encourage, please step outside in the hall, do so. These proceedings are being recorded by audio and visually. The board will vote on each case and make a decision at the end of the docket. You're welcome to stick around to observe that if you like. Otherwise, you can call the BMZA office tomorrow morning after 9. The number is 410-396-4301. Again, 410-396-4301. In any event, you should receive your resolution in the mail within 30 days from today. We ask that you not do any work until you receive your resolution in the mail, and please don't do any work in the city without pulling the proper permits. There are some matters that have been postponed from the docket, but only one which we need to call. Calling the case, where's the number on here? 2020-36, 7120 Park Heights Avenue and 7124 Park Heights Avenue. Mr. Prettle?
Afternoon.
Good afternoon, sir. You have a postponement request for this matter.
That's correct. I received a letter from the planning department this morning with address a few items which are concerning to the developer, and we'd like a couple weeks to address that and come back before this board.
Okay. There's no opposition. Any concern from the board? Okay. Postponement granted. Thank you, Mr.
For your 844 Park Avenue, has that the postponement already been granted, or it was less than 48 hours prior to the?
I believe we have resolved that.
Okay, thank you.
Yeah.
Wait,
44?
nope,
That's 32, 2020-32.
that one's postponed?
Got it.
Oh, you're right, that's the adult daycare.
Yeah.
3701 Emerson Avenue,
Is that a postponement, Mr. Riddle?
2020-22.
Oh,
Yes.
did we know that? I don't think
32.
we knew that.
Oh, wait a minute.
32.
Emailed to the board yesterday.
I didn't have it on my list, so you can
Okay.
request the postponement here today.
Would like.
Let me call.
Yeah, because they said that.
I'm sorry. Are we at case number 2020-22, 3701 Edmondson? No?
32, Mr. Chairman.
32.
2020, 32.
Calling the case of 2020-32, 844 Park Avenue. And this was across the use premises as an adult daycare center, and you'd like postponement.
Correct, and I have here Peter Bosworth, a representative of Beemore Clubhouse, who is the contract purchaser in the building, and we're still negotiating with the community. I think we're almost there, but we'd like 2 weeks, if possible, to resolve the discussions and be back in front of you.
Okay. Any objections from the board?
Yeah.
All right.
Thank you.
Postponement
Thanks.
granted. Okay, 22. Just a little bit of housekeeping here, folks. Give me one moment. Yeah.
You're reading out the postpone.
Okay, we're going to now go to our consent docket. Consent cases are those cases for which the board has concluded we have sufficient information to grant your request. When I call your case number, please line up to my left. The first case will be in front of me, and then, again, to my left down this side. We will swear all the parties at once, and then we will address each of your cases. Those cases are as follows. Case number 2020-21, 533 East Giddings Street, Nate Prettle. Case number 2020-23, 601 South Decker Avenue, Idan Zamaret. Close?
Monday.
All right. 2020-24, 621 South Conkling Street. Stephen Preparis. Case number 2020-25, 635 South Curly Street, also Mr. Prettle. And is there one more? It? Looks like that's it.
That's it.
Okay,
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
okay. Case number 2020-21, 533 East Gidding Street, Mr. Prettle. This is a request to construct a two-story rear addition with a rooftop deck. Is that correct?
That's correct.
All right, do we have any staff reports?
Martin French for the Baltimore City Planning Department. Planning Department has no comment on this application. Thank you.
Thank you, Mr. French. Mr. Prettle, is there anything you'd like to add to your application? All right, well, the board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
Thank you. Case number 2020-23, 601 South Decker Avenue. And sir, tell me how to say your name.
Idan Sameret.
Idan Sameret. All right, sir, this is a request to construct a second-floor overhanging rear addition with a rooftop deck. Is that correct?
Yes, it is.
All right, do we have any staff reports for this property?
Planning Department has no comment on this application. Thank you.
Sir, is there anything you'd like to add to your application? All right, well, the board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you very much.
Have a great day. Case number 2020-24, 621 South Conkling Street. Mr. Papiris. This is a request to construct an enclosed attached rear garage with carport with a rooftop deck and an enclosed attached street side garage with a rooftop deck. Is that correct?
That's correct.
All right. Do you have any staff reports?
Planning Department has no comment on this application. Thank you.
All right. Sir, is there anything you'd like to add to your application?
No, thank you.
Okay. The board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you.
Thank you.
You did.
All right. All right, case number 2020-25, 635 South Curly Street. Mr. Prettle, again, this is a request to construct a two-story rear addition with a rooftop deck, correct?
That is correct.
All right. Any staff reports?
Planning Department has no comment on this application. Thank you.
Is there anything you'd like to add, Mr. Prettle?
Sure, I'm here with the property owner developer Milan Stankovic, and also add that you should have a letter of support from the Canton Community Association in your file.
Okay.
Or an email at least, if not a full letter.
All righty. That being your presentation, the board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
Thank you. Okay.
Mr. Chairman, if I could interrupt very briefly, just to make sure I didn't miss any other postponements on my list, since I did that once today. We have a couple postponement requests going in case number order 2020-22, 3701 Edmondson Avenue, Turiani Hashimi. There has been a request for a postponement. The board had granted that request, so unless there's anyone in the audience that is here to oppose that request for a postponement, the board had previously postponed that case. Great. And then next one, 2020-30, 2930 Baker Street, Marjorie Lewis. Also, the board had approved or had postponed that case prior to today's hearing. Park Avenue was just postponed, and then Park Heights Avenue was also postponed by the applicant several minutes ago. Thank you, Mr. Chair.
Thank you, Mr. Rolgaard. All right, we'll now turn to our regular docket. Do we have any signees for opposition today?
We have two cases in which opposition was signed in. First case is 2019-439, 1611 Guilford Avenue. And then the case that was just postponed, 2020-22 for 3701 Edmondson Avenue.
Okay. With regard to the case number 2019-439, 1611 Guilford Avenue, parties, I know, okay, Mr. Burgunder? Yes. Okay. All right, have you had an opportunity to speak with the applicant? Okay. Is there any need to further discussion? Okay, thank you. All right. Okay, So let's get started. Case number 2019-179, 4909 Hamilton Avenue. Mr. Prettle?
Afternoon.
Good afternoon, sir. This is a request to amend the prior approval to construct a two-story multi-family dwelling unit containing a total of 42 dwelling units, correct?
That's correct.
All right. Please swear the witness, please.
Raise your right hand, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, do we have any staff reports?
We have nothing from the community, but just to confirm with Mr. Prettle, the property was properly posted on 3 sides.
It
Is that
was.
correct? Okay, thank you.
Right.
Planning Department simply wishes to note for the record that the amended plans should show 2-story development, not 3-story development. Thank you.
Okay, do we have the latest plans for this project?
You do. I think the, what Mr. French is referring to, one of the plans, there may have been a notational error, but the project has not changed other than what I'll hopefully briefly describe and why we're here in front of the board.
Okay, the floor is yours, sir.
So the proposal is to build a multifamily dwelling, 42 dwelling units, 2 stories, and it underwent a significant community and city review process during pretty much all of 2019, culminating in an approval with multiple variances before this board. After that approval, as the site details, utility plans, et cetera, were worked out with the city, and the design was refined, particularly the site plan review committee meeting with the planning department, there was a suggestion and sort of a necessity to bump the parking area behind one of the one set of buildings on the Hamilton Avenue side a couple feet. And what this did, it created an additional parking spot, but it also moved the set of, we call them like townhouse style apartments, slightly towards Hamilton Avenue. And the front yard setback was between 25 to 27 feet before. Now it's a uniform 20 feet. The required findings that the board made still at the last appeal absolutely apply to this, and we urge the board to approve the change to the front yard setback for a portion, about a third of the dwelling units.
Okay.
And the community has been notified multiple times, and they are fully aware of this.
All right. I do recall this project and the presentation and the board's approval. Are there any questions from the board?
No.
Anything else you'd like to add, Mr. Prettle?
Sure, I'll add, from a practical standpoint, this project is exactly the same as it was. If you were to go out on the site, you wouldn't look any different, with this proposal versus the last one. Even if you were to look at a plan, it's really a minor, almost technical change.
Okay. All right. Thank you for your presentation,
Thank you.
sir. Calling the case of 2019-384, 3507 Edmondson Avenue, Gregory Bennett. Mr. Bennett. All right. Bennett. So no show for now. We may recall that at some point. On the matter of 2019-439, 1611 Guilford Avenue, Guilford Brewing LLC. Good afternoon.
Mr. Prettle is coming right now.
Okay. Let's get everybody here, then we'll swear you all in.
I swear, Nate's already been sworn, so.
Yeah.
Everybody just raise their right hands, please, if you're gonna testify. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Okay. So, Mr. Prettle, you're here on behalf of Guilford Brewing LLC,
That's correct.
and this is a request to use the second floor for live entertainment. Is that correct?
That is correct. Well, actually, this has been modified slightly. I discussed this with the zoning board staff attorney, and it's to use the premises as live entertainment as accessory to the already approved restaurant, brewery / tavern.
Okay. Do we have, accurate? We have any staff reports at this point?
Yes. First, we have 2 letters from 2 residents indicating that they are in support. We have 6 letters from a variety of businesses and developers who indicate that they are also in support.
How many letters total?
6 from corporations and 2 from residents. We also have a 16-item MOU signed by both parties with 12 terms attached to those MOUs.
With what?
12 terms. Is the applicant, is everybody in agreement with them?
Yes.
Oh, okay. So, Mr. Burgunder, who are you here with?
I'm here on behalf of Guilford Avenue LLC, and this is Mr. Louis Linden. Guilford Avenue LLC is the immediate next-door neighbor at 1601 Guilford Avenue.
Okay.
It's the pork building.
Did you
It's a
and your
co-op.
client have a chance to participate in the negotiations between the brewery and the New Greenmount West Community
So
Association?
my client is on the board, and, I'm sorry, on the development committee of the neighborhood association. He attended the meetings and then was not informed at all of the negotiations that took place without him or representation of the immediate next door neighbor as well. When we were here on the prior time that this came before the board and there was a postponement, I provided my business card and information to Mr. Hurdle, who was the attorney at the time, and asked that I be kept informed of any negotiations over any MOU. We were not informed at all about it and do not support it.
What's the problem with the agreement that the neighborhood association and the brewery reached?
We believe it contradicts the PUD, very specifically. We believe it's not permitted by the PUD at all. In fact, it's specifically prohibited. As well, it's essentially a meaningless document. It does not include anything other than a basic statement that we will follow the law. It doesn't address parking. It doesn't have any consequences
How do you think that it's meaningless if an attorney for the neighborhood association negotiated with the brewery?
because it doesn't include any impact or an attempt to soften the impact on the immediate neighbor. It also doesn't address the underlying legal issues as it relates to the PUD, which governs the entire neighborhood, and it also doesn't include any meaningful consequences for a violation of it. And so I
Have you
believe.
had an opportunity since seeing this MOU to talk to them about possibly amending it to include some language about them coming back before zoning if there was an issue, or?
We haven't, because it violates the threshold issue, which is that it's, the use is not permitted.
But I understand what you're saying, but that's your argument. I'm sure that they have a different interpretation. Is it worth stepping out into the hall to have a conversation to discuss a possible, I see you're shaking your head.
If there were a way to work it out, it would be not in the hallway today. We should have been included in the conversation.
That ship unfortunately has sailed, and I doubt, knowing the representatives who are here today, that was done on purpose. It would be hard to believe, just because they've appeared in front of this board so many times. I have a hard, and given what I believe to be, what I know to be their veracity, I have a hard time thinking that they would.
I'm not saying it was done on purpose at all. It was certainly, it was done, if it was done inadvertently.
I understand, so even if it was done inadvertently, there could be an opportunity.
There could be an opportunity here, but Mr. Linden would have to consult with the members of his, that live in the building to make sure that they had an opportunity to meaningfully participate. That's why they
Is it
asked him
an
to be the
apartment
representative.
building?
It's a co-op building.
Co-op, okay.
How
Is
many,
the-
I'm sorry,
Oh, go ahead.
how many residents live there?
There are 9 of us.
And if I understood you earlier, you are a member of the, you're on the board of the, well, hold on,
Development Committee of the Greenmount West Community Association.
you're on the development committee.
Yes.
And so you do agree that Lauren Washington is the president of New Greenmount
Yes.
West Community Association?
Yes.
Okay. Did she have authority on behalf of that association to sign MOUs?
To the best of my knowledge, but,
Okay.
you know, I'm not a Maryland lawyer. I assume she does.
Okay. Mr. floor is yours. Let's hear from you, sir.
Good afternoon. I'm Nate Prettle. I'm here with Stefan Popescu and Rich Kraft, who are the owners, operators of the Guilford Hall Brewery, Restaurant, Tavern, and Brew Pub. I'm here to talk about a conditional use request for live entertainment as accessory to those uses. Before I start, I just received a letter of support from 12th District Councilman Robert Stokes, echoing the community's support with the condition of this memorandum of understanding. If I could address that before I get into it, I became involved in this project after the last postponement, when it's my understanding that Abe Hurdle was the representative.
Would you like to?
At that time, there was some discrepancy about whether this would be a request for a principal use live entertainment or for live entertainment as accessory to the existing principal use. And that's what we're here for today, is accessory to the existing use.
Let me stop you for a second. Mr. French, did I ask you for staff reports? I may not have.
Not yet.
Now I'm doing that. Sorry to cut you off.
okay.
Let's see what planning has to say.
All right. Planning Department has reviewed this application several times. It's noted that, among other things, this property is contained in the Greenmount West Arts and Entertainment District Planned Unit Development, which is the PUD that is being referred to in the testimony. This particular application, the department noted, did not include statements relating to the off-street parking spaces that would be needed in support of live entertainment events, patrons needing places to park. There was information given to the department stating that there was a nearby property that could possibly have been available for use of its parking lot during evening and nighttime hours, but there had been no formal agreement presented concerning that. Very specifically on the issue of the PUD itself, the Planned Unit Development Ordinance contains several references which have led the Planning Department to conclude that the PUD is in fact an obstacle to approval of this particular application at its final moment. First is in the ordinance which established this PUD, it states specifically restaurants and lunchrooms, but not including live entertainment or dancing, are permitted. So there is clearly an intent in the legislation to prevent live entertainment in this particular planned unit development in that context. There is also a statement in an amendment to this PUD, live entertainment would be permitted as accessory to an art gallery use, provided no admission, donation, or use charge is required, and such entertainment is limited to non-amplified music, which may or may not be consistent with the application that was presented to the board. So on that basis, the Planning Department had recommended a deferral of this hearing of the application, or the full hearing of the application, to allow time for the introduction of a bill to repeal the Planned Unit Development Ordinance that currently does not authorize live entertainment accessory to a restaurant or tavern at this location, and to allow the applicant time to complete arrangements for provision of off-street parking to serve the anticipated patrons of the proposed use, and also a security plan covering live entertainment events. And that's the limit of our comments. Thank you.
Councilman, about the potential of introducing legislation about it?
So we've had general conversations about it. We have no problem repealing the PUD and being a part of that process. It's not up to an individual property owner. It's up to the New Greenmount West Association and the entirety of the property owners within that PUD. And when the board's ready, I think if I could address a couple of the comments from the Planning Department, which I don't disagree with, but I don't think they tell the whole story.
Or is the brewery looking to have live entertainment?
I guess I'll let Mr. Pescu and Kraft talk.
Just very quickly for the record, there's one other letter in opposition that was, I believe, read into the record at the first hearing, but just so the record's clear. This is from the principal of a company called Lewis Direct, and they are in opposition to the appeal. We also have a letter from counsel from Mr. Burgunder representing Guilford Avenue LLC, dated January 14th, 2020.
Thank you.
If I may, but maybe before we get into some of the specifics, because if the board deems they're not necessary, why go there, address the Planning Department's position on the PUD, if that's okay. So the property is located in an IMU zoning district. However, it's also located within the Greenmount West Arts and Entertainment Plan Unit Development. And that PUD specifically refers back to the former zoning code. So we're in a situation here where we're bounded by the regulations in the PUD as well as how they refer to the old zoning code. And both of the statements, I think I would agree with Mr. French. One, in the permitted uses, and it's important, in the PUD is that the following permitted uses are allowed throughout the PUD. And a specific designated land use called restaurants, but not including live entertainment and dancing, is one of those permitted uses. However, if you go to the next section or two sections down, it says, in addition, all uses considered conditional in the M1, B1, and B2 district are considered conditional within the PUD. And then we have restaurants and taverns, including live entertainment and dancing, are listed as conditional uses by zoning board approval in the old zoning code. So that's sort of the zoning framework that we're here requesting for live entertainment. And I'll just touch on it. We did work closely with the new Green Mountain West Community Association as well as their council, Ms. Witt, to come up with this MOU. Any allegations of someone being left out certainly would be inadvertent. I'll let Mr. Popescu briefly discuss. I think he had reached out personally to Mr. Linden for what that's worth.
Can you reference or address the parking issue?
Sure. I'll let Stephanie, you want to talk a little bit about your proposed plans? And this came up in the MOU as well.
Sure. The parking and security plan, we have spoke with the community association for the last 2.5 years. The security plan, we will have a full-time security company that will run our security, not only carding at the door, but also security on the street and security inside. We'll have a camera system per the MOU that will have all sites on the street as well as inside the establishment as well, and we will sign up for City Watch, so the police will have access to all our cameras as well. We own a lot of property throughout the city, and all our properties are signed up with City Watch. As for parking, we have reached out to the Montessori school across the street. One of the letters of support is from Allison, who's the principal and owner of the charter school, and she's in support of this project as well, and she will allow us to use her parking lot after hours. We're also in works
How
of
many spaces does that provide, if you know?
28.
28?
Yep. And we're also in process of purchasing one of the lots right next door to our property, which was part of a townhouse development. We're working with Edgemont Builders and Ted Rousseau to have one of the lots that was given to them by the RFP given to us to extend our parking lot on the property as well. We have parking on the property, but now this will extend to another 8 to 10 spots. I believe the Board of Estimates is meeting on that tomorrow to approve the sale, which will be closing pretty shortly afterwards. So that will be another 8 to 10 spots. We also have plans to do valet parking and use the Amtrak lot. The Amtrak lot has hundreds of spots, which we'll be paying for our patrons to come and use valet on a Thursday, Friday, Saturday night. And of course, if we're busier than that, we'd be happy to valet. We want it to be a good experience for our customers, that they're able to come, enjoy their time, and then leave in their car without walking 5 or 6 blocks to get parking.
Do you have to enter into negotiations with Amtrak to utilize that lot?
It's a paid lot, so we can use it as needed. If we did see it as a more repetitious nature, we would then obviously try to do monthly, 6-month, a year parking. We have reached out to the social services building, which is catty corner to us, but that was 3 years ago. They were open to it, but we haven't reached out to them since.
Okay.
And they also don't use their parking lot at night.
Do you own the adjacent lot that you,
We will hopefully own it
for
within
parking?
the next 30 days of closing. Once the Board of Estimates approve the RFP release of the lot, we will be using that as well.
Okay. What else would you like to add, Mr.
Sure.
Brunel?
Go ahead. Yeah. So I did reach out to Lou. Actually, Lou has my personal cell phone number. I have Lou's personal cell phone number. The building is the original Crown Court Conceal Factory. A lot of the inner workings of the buildings are connected, such as the fire sprinkler system. So we are in open dialogue at all times when we have to test our fire stuff and when they have to test their fire stuff. We also have a deeded restriction that allows us onto their property at all times to check the fire systems. I did walk him through the property about a week and a half ago and tried to explain all the soundproofing stuff we're doing on the neighboring wall. All the brick On the neighboring wall will be covered. Anywhere there's live entertainment, there will be soundproofing. We'll be using mineral wool, which is the #1 for soundproofing insulation. We're also going to be doing channel locks on all the walls.
So all of this is really great. And I know, Mr. Prettle, you didn't want to do a deep dive into the facts, but I am curious, how, are we talking like bands, acoustic, DJ?
Bands,
Okay.
DJs. I mean,
So
what you would
would
see
be
in a bar in Nashville if you went, or Fells Point. So you would have.
So the
like-
soundproofing is definitely necessary.
And we've done it, and the entire building has brand-new windows. We've double-paned all the windows. You barely hear anything. We've turned our music speakers all the way up. You don't hear it on the street.
How late would the music go till?
12 o'clock during the week, and I believe 2 a.m. on the weekend, but obviously we'll have last call somewhere around 1:30.
Have you ever heard any live, so breweries are entitled to 12 special event permits a year, and there's unfortunately that they're legally entitled to that. Have you ever heard this sound from music coming from the brewery?
It hasn't been because it's not a brewery yet.
Okay.
We
So
haven't-
you guys aren't open?
We haven't opened yet.
They don't have a use permit.
The-
Okay.
There's only sound that's come across right now when we were demoing pipes, because some of the pipes went through our walls, so any vibration, et cetera, would go through. Our soundproofing isn't up yet on their walls, so they do hear our construction every now and then. But the second we're finished putting all our drywall and insulation, they really should hear very little. The only sound that would be going across would be mostly through their windows, which are single-pane windows, because they're historic.
Okay. With regard to the timing of the live entertainment, your application references generally 6 p.m. to 1:30 a.m., 7 days a week.
Right, so we will obviously follow the MOU on top before we follow that. The MOU restricts us to 12 o'clock during the week, and weekends allowed till, I think, 1:30.
And still accurate as your application indicates, you'd be having live entertainment several times per month, maybe 2 to 3 times per week.
Correct, yes. So, I mean, if you're coming in on a Thursday night, we'd like to have a band to keep people entertained. We don't want to be, just ambient music. We'd like it to be in some sort of, feel-good space, kind of where all the other cities, Austin, Nashville, DC, New York, you go into these big, open factory areas, and you have a band, you have different things going on that keeps people entertained.
Okay. One second. Mr. Prettle, is there anything else you'd like to add on the issue of the authority to have live entertainment other than what you've stated?
Sure, yeah, I think I've addressed that, and the only thing I would add is that we have not heard any substantive opposition to this proposal. The only thing I've heard is it's not allowed by the PUD. Not that, it's too loud, there's not enough parking spots, we don't like music, we don't like breweries, nothing like that. It's just, well, it's not allowed by the PUD. And in addition to that, again, as presented, we have support letters from the councilperson, the community association, along with an MOU, the school across the street, other neighbors. And so we really think this would be a great addition to the neighborhood. And, I'd urge the board to approve our application.
I 100% agree with you, but the purpose of a PUD is to plan it out so that things like this don't have to, there is an ambiguity about things like this. And I agree that this is like a unique situation and there should probably be an exception, but my concern is what the law says.
Sure, I would agree with that. That is the purpose of PUDs. In reality, that doesn't always happen. And I've seen PUDs that are more confusing than this one and acknowledge, this isn't clear cut. But the way that I read that is that all conditional uses in those zoning districts are conditional within the PUD. And there's plenty of PUDs that refer things back to the zoning board. And that's not an unusual situation.
Let's say that we give you
Mhm.
the use, they're going to appeal.
Yeah.
And then the circuit court is probably going to send it back.
There's nothing that we can do about that here other than, we have a use and a proposal that we feel is good for the neighborhood.
Have you talked to the neighborhood about supporting you with the repeal of this portion of the PUD?
Yeah, sure, please.
So we talked, I talked to both Adam and Lauren. One was president and the next was president during this time of building. And I've talked about repealing the PUD. Obviously, I have no horse in the race with the PUD. In my eyes, actually, I'm a little bit better with the PUD than I'm with Nout.
I'm not
But
talking about repealing the entirety of the PUD. I'm talking about
that would be the only option.
addressing this portion of the PUD. This would be an opportunity
So
for you to
the-
talk to the neighborhood.
The issue is a lot of the things that happen in this PUD protect buildings like Lou's Co-op that allows him to do welding in the building without any special safety features and all that come along everywhere else. There's the Copycat building, which is next door to that, who also is allowed to pretty much have stores and et cetera within their apartment based on this PUD. And I'm loosely defining this.
I'm familiar with Copycat. It's an
Yeah.
interesting situation.
So because of that, I believe the opposition from the neighborhood would be a lot stronger if I was going to do anything with the PUD, especially repeal it rather than just amend it. I would like to take a second and just,
I think there's enough of a, because of the old zoning law, and because of the district that you're in and the PUD, that there would be potentially a way not to repeal it, but to do like some sort of end around, propose legislation that clarifies.
I think we would be happy to explore that, and I think that's a good option. In the meantime, we're going to ask for what we're here for today. And remember, the PUD is the Greenmount West Arts and Entertainment Plan Unit Development. I've heard some things that, PUD was created to not allow music or not allow, it's literally called the Arts and Entertainment Plan Unit Development.
No, I would admit that it's unusual that
and I just want to echo.
everybody else would have the right to do it, but not you.
I just want to echo one more time. It clearly states in line 22 of this bill, in addition, all conditional uses of M1, B1, and B2 districts are conditionally allowed through the PUD, subject to the requirements provision of Title 14 of the zoning code, meaning I come before the BMZA asking for it. And then it's clearly in the code that B1 and B2 allow conditional uses for live entertainment as an accessory to restaurant. I understand where they're saying there's different allowances of not having live entertainment in different sections, but those sections are for permitted uses without the BMZA blessing. It clearly states that if we have the blessing, these are all allowed based on the old zoning code, and in the zoning code it is. And I am more than happy to listen to any material complaints or anything from the neighbors next door, soundproofing, even being a good neighbor. And unfortunately, we haven't really had those discussions, but I'm, again, happy to be a good neighbor, because at the end of the day, they're not going anywhere and we're not going anywhere, and we have to live with each other. So whether or not you guys enforce it or not upon me, I'm still going to be talking to Lou openly about whatever issues his tenants may have.
Okay.
I think it'd be helpful to hear from Mr. Burgunder about the language of the PUD, unless Ms. Witt has something to add.
I just wanted to give a 1-minute description of who I am and why I'm here.
That would be nice.
Yeah, so Becky Wood on behalf of the New Greenmount West Community Association. I just wanted to say that the association is in support of the live entertainment, subject to the conditions that are in the agreement that you have in front of you. I just wanted to submit a letter of support, which basically just says that. And we have no strong opinions about the PUD or the need to repeal the PUD or amend it. If that needs to happen, we could have further talks about that.
Oh, okay. Dee?
Go ahead, sir.
Thank you, Ms. Witt.
Mr. Burgunder, go.
I don't know if Mr. Prettle is finished with his case in chief.
Thank you. Yes.
Well, he has
Yes.
the last word.
That is true.
Yeah.
But I said, I phrased it case in chief.
Yep,
Okay.
you did.
Obviously, he's permitted to say the last word. So I have prepared opposition to the petition with a memorandum of law that describes the issues that we see are before this board today.
Sure.
And I think that the main issue here is sort of the opposition comes into 3 categories. The first category is that the application itself is incomplete. And the application itself actually conflicts with the petition. So the application is the application for the conditional use authorization. So that's this document. And then we're here on, by the good graces of the petition for zoning relief. So the petition, I'll call it capital P petition, and the capital A application conflict with each other. But first, I'll begin with so the first thing is that the application is incomplete and conflicts with the petition. The second is that the PUD specifically prohibits the type of use that they're requesting. And I'll explain the rules of statutory construction, which you all know, that would address that issue. And the third is the issue with regard to the parking and the conditional use application efforts. So first, with regard to the application. The application, which is the conditional use authorization application, says that the restaurant and the brewery is not operational. So to have a to have an accessory use, you need to have a principal use. And the principal use has not been permitted. It's not open, it's not running. That would be our preference, which is they get the restaurant open, they get themselves operational, they act like a good neighbor without a good neighbor agreement, and then we revisit this issue at some later date once they've established themselves as open. So I would argue, just based on principle, you can't have an accessory use unless you have a principal use. The principal use has not yet been permitted. There's no use and occupancy permit for the.
But can't those things happen simultaneously?
They could happen simultaneously.
So there's a request before the board for whatever that use might be, and whether the principal use is allowed by right or conditional, can't those things happen together? So if there's a restaurant use that's coming online, can't this board authorize an accessory use to that restaurant use condition upon the formal UNO being issued for that principal use?
Right, and I raise the issue for two reasons. One is that I think technically, yes, you are correct, but I think my main point is that it would be wise for this operator to get its operation open, its brewery, its restaurant, act like a good neighbor, and show my clients, the right next door neighbor, that they are going to be good citizens without having a good neighbor agreement, that they're going to be running the place in a way that is responsible. I guess that was my main point. The application also does not include the fire rated capacity for the space. So section 14319A2 of the zoning code requires that the application specifically list out the live entertainment and dancing venue within the establishment. There isn't anything on the plans. There is a square hand-drawn on some prepared plans by an engineer or surveyor, which says stage, but there isn't anything that shows the dancing. It says in subsection Romanet 3, it says if dancing is to be provided, the location and dimensions of the dance floor must be provided. There is no location or dimensions of the dance floor, so therefore the application is incomplete. The maximum, so section 14319A2 also requires that the maximum authorized occupant load as approved by the fire department must be shown on the plans. It's not. And in fact, the application itself clearly says that the fire department has not been there yet to determine the maximum occupant load. So I don't see any.
They don't have the use permit. That comes right before they issue the use permit.
No, they don't have the fire safety.
Yeah, but that's part of, you go through a series of inspections and they just
Sure.
haven't had it yet.
So-
They're not gonna get the use permit without the fire inspection.
That is true, but you can't, if the law requires you to say what how many people are going to be there, how would the board know that it's going to be 1,000 people or 100 people? How would the neighbors rightly know what the impact is going to be on them without the fire rating capacity? Plus, the statute says shall.
I hear you.
It's a fair point, but would it surprise you to learn that the fire marshal will not go out to a property before a BMCA has approved the potential use?
That wouldn't surprise me, but it's the opposite of what the law requires.
Fair enough.
So I think we're somewhat bound by the law. I appreciate the fact that the fire department, since the fella, I forget his name, who retired, moved to Florida, John, you remember?
I can't recall his last name, but yes.
Carr,
John Carr.
Yes, Chief Carr. Since Chief Carr retired, moved to Florida, I would say that potentially the fire department's been a little less cooperative, but that doesn't undermine the fact that the law does require it. So that would be another thing that this board should consider.
As a quick follow-up, a complete application is determined by which entity within the city of Baltimore for a zoning appeal? Sorry, I'll rephrase. So a complete application before the board, which entity or agency or individual would determine if an application is complete? If you know.
I don't know. I assume it would be the
Zoning administrator, that's correct. So that office would sign off on an application being complete and then would send it to the BMZA for further review.
Right, and that's why we have this appeal, because the determination of the zoning administrator is not final, and that's why we're appealing it. But the application also doesn't answer all of the questions or provide the basic information. As well, the application very clearly on the front of it says that live entertainment is not an accessory use. So the application before the board as today is that it is an accessory use, although the application says it's not an accessory use. So the question is, which is it? But that's sort of beside the point. The PUD, if I could address the PUD issue. The PUD issue is frankly not that complicated. There are rules of statutory construction. The PUD in section 3B says that restaurants are permitted, but not including live entertainment or dancing. Live entertainment or dancing, as Mr. French said, is permitted with regard to an art gallery, but not amplified music. This is an artist live-work neighborhood. That's why it was created. That's why the people in the Guilford Avenue LLC building, the Copycat building, and many other buildings in the neighborhood, it's live-work space for artists. The legislators, I don't know if Councilman was part of the group of legislators that passed the PUD or the amendment to the PUD, but the legislators sought and set out specifically that live entertainment and dancing is not permitted accessory to the restaurant. The argument here today is that there's a section, 2 sections below, that says, in addition, any other use, conditional use in the underlying zoning. Well, that would essentially require the board to read out of the law the specific in favor of the general. And that's the opposite of what the rules of statutory construction say. So the legislators drafted it, they approved it, the mayor signed it, it became law, and the very specific requirement is that it's not permitted specifically. And you can't go to a general section and read out the specific. That's a basic rule of statutory construction. And the zoning code, section 13-102C, does say for PUDs, it says that permitted and conditional uses of the underlying zoning district, in this case it's now the IMU 1, it says unless specifically prohibited by the planned unit development. So in addition to the fact that the PUD very specifically says no accessory to a restaurant, live entertainment, or dancing, the zoning code says you can look to the underlying zoning district, which today is the IMU. It wasn't at the time. There wasn't an IMU, but today it's the IMU. And you only look to the underlying district unless it's specifically prohibited, but in this case it's specifically prohibited. But let's say you look to the underlying industrial mixed-use zone. There is not permitted in the underlying zoning district. If you look to the zoning chart 11301 for industrial and mixed use 1, it says, there's a category, it says entertainment, live, accessory to a restaurant, tavern, art studio, or art gallery, and it's got a blank in it. There's nothing in the space. It's not a P for permitted. It's not a C, B, or a CO. It's simply not permitted. So what the zoning code anticipates is that there is the opportunity to look past the PUD to the underlying zoning district unless it's specifically prohibited. In this case, it's specifically prohibited. And even if you did look past the fact that it's specifically prohibited, it's not permitted by the underlying zoning district, which is this case is industrial mixed use.
The applicant suggests an alternative interpretation of, is that 3B? Yep, 3B. And it says, in accordance with the provisions of 9303 of the zoning code, the following B1 and B2 uses are allowed on the first or ground floor of the buildings, et cetera, et cetera. Can't the board interpret are allowed, meaning permitted by right uses? So
only if the board ignored the statute and the rules of statutory construction.
But we only get to the statutory construction ambiguity issue if on the face of the document there's any question. So if 3B says, for example, if the board interprets are allowed to mean permitted by right, and if the board would find that 2 paragraphs later it says all conditional uses in the M1, B1, and B2 are allowed as conditional to the board, can't the board read that to mean on its face that these uses permitted by right are simply allowed? No board review, no city council review. And then 2 paragraphs down, the document on its face suggests that conditional uses in these 3 prior zoning districts remain conditional in front of this board. So don't we, if you look at the document on its face, can't the board interpret those provisions in that way?
I'm not saying the board can do anything or they can't do anything,
Oh.
but what I would tell you is it would violate some basic rules of statutory construction. So I don't think that
But
the
only if
board-
the board found that I would agree that the specific governs the general. But if you read this language as simply as possible, and it says, these things are allowed by right, and these things are allowed by conditional use, is that violating any kind of statutory construction to read it in that way?
Putting aside your argument that your other argument, I mean, what is the answer to that question?
The answer to the question is, yes, it would violate the terms of the PUD. I appreciate the fact that
That's not the answer to the question.
well, if the only answer to the question is, I agree with you, Mr. Baumgartner, then that's not the answer I'm going to give.
But he's asking.
And that
can you
wasn't the
look at
purpose
it-
of my
that wasn't
question.
the
No,
purpose of
I
the
understand
question.
that, no, there is,
Very conflict, this is actually like not a, I don't think,
The-
you always look so perplexed when I speak to you.
I'm not suggesting I'm perplexed, I'm trying to understand, I'm trying to,
This isn't a black and white issue.
Oh,
We
I-
all agree with that.
Can we?
I don't, I'm sorry.
Talk over each other?
Sure. I don't, I agree, I agree that there is a level of complexity to it, but I don't agree with the idea that you can read the 2 paragraphs down to permit something that is specifically prohibited 2 paragraphs up. There is no way to marry the statute and to rely on the plain words of the statute to explain away the fact that, and I appreciate Mr. Baumgartner's suggestion that you could read it this way, but I don't believe that there's any way, and to follow the words of the statute as written by the legislators, to say, that have the legislators say in paragraph 3B, you can't do it, and then to suggest that the legislators intended, when they wrote the legislation, 2 paragraphs below to say, without specifically saying it, please ignore what we said in paragraph 3B, because now we really mean that you can do it, except for the fact that the statute also says that unless otherwise specifically prohibited. So I don't think you can read out of the law 13102C. 13102C says you can do it unless it's specifically prohibited, and the only way to get there under Mr. Baumgartner's interpretation, or his suggested interpretation, would be to overlook both the plain words of the statute and the fact that the law, 13102C, says unless specifically prohibited, and in this case, it's specifically prohibited.
As a final thought on this very abstract, esoteric, first year of law school examination.
Maybe let's go second year.
Second year of law school. Isn't there also a rule of statutory construction that says a statute should be read in harmony when possible, and that only when it cannot be read in harmony as an entire document, then do you go to other avenues? For example, if the board could read these 2 together and say, yeah, the legislature intended that these are permitted things and these are conditional things, that a rule of statutory construction would be that an administrative board or a judge should try to read them in harmony if possible, and if not, then we would go with that either the specific governs the general, or that they're conflicting, and that the use would be prohibited. Unless I lost you. I might have lost you.
I think you lost me a little bit there, but I
Okay.
think that we could debate different rules of statutory construction, but I don't think that there's any way to harmonize. The only way to harmonize it in the way that you're suggesting is to use harmony, we'll use a music metaphor here, to harmonize out the provision that says, but not accessory to a restaurant. And I think that you compound that with the fact that the underlying zoning district, which is today the industrial mixed use, also very clearly has a statement of intent by the legislators to say that you can't have live entertainment and dancing as accessory to a restaurant. So it'd have to be like a double overread. So you'd have to read it out of the read it out of the PUD, and then you'd have to read it out of the statute. So I don't think that's a burden that can be met today. If I could,
Thank you for that fun
it was always very interesting.
back and forth.
if I could also, if I may also address the parking issues. So the zoning code also requires that there be sufficient parking. On the plan, there are 0 parking spaces shown. So at this point, there's nothing being provided. And I appreciate the fact that the owner of the property has reached out to the Montessori school and reached out to a paid parking lot, which is not really reaching out. But the statute also is very specific. And again, I didn't write the law. I'm asking this board to interpret it. And it says an off-site parking lot must meet the following requirements set forth in Zoning Code 16-401C. And 16401C, as this board likely knows, is that our off-site parking facilities may be located off-site and has conditions as to what those conditions are. The parking facilities are located in a zoning district where this parking is permitted or allowed as a conditional use. There's no testimony here today. I don't know whether the underlying zoning districts in which these parking lots, obviously the parking lot that's at the train station is a parking lot likely permitted, but we don't know whether accessory or non-accessory parking is permitted on the school's grounds. But even if that were true, the off-site parking facility must be on a lot possessed by the record title holder of the lot occupied by the structure or the use served by the parking facilities. And basically it says that there are 2 requirements to it. One, it has to be done by deed. There's no evidence of a deed here. There actually isn't an application before the board for a parking variance. Or 2, it has to be a 20-year or longer recorded deed restriction on the property. So there hasn't been any evidence of that. And with regard to the acquisition of the additional lot, I happen to represent Edgemont Builders, but it's a row house lot. So for there to be the suggestion, there isn't anything in the plans that you've been provided, and I don't think it's fair for this board to to issue a ruling without seeing the plans. But there isn't any suggestion that a row house lot in Baltimore City would be sufficient for the parking of any vehicles, much less 8 vehicles, and also have a throughway so those cars could come in and out safely. So I don't think that it meets the requirements of 16401C. I also don't believe, as set forth in my memorandum, that the requirements for the conditional use have been met, even if this board were to determine that they did have the ability to do so. There hasn't been any evidence that a use at this location is appropriate. It's not permitted by the underlying zoning. Mr. Linden, were he to testify, would testify that this is right next to a live workspace for artists, and the proposed request would cause extreme hardship on the people who've lived there for a long time and who were the principal beneficiaries of the underlying PUD to permit this area to be converted to, frankly, an artist's neighborhood. And therefore, I don't think they can meet the requirements. They certainly cannot meet the requirements to receive a variance for the parking that would be necessary to support this use. So for all those reasons, we'd ask, in accordance with the memo that I've submitted, I'd ask that it be entered into evidence that the board deny the request. We would love to see them open up and be a good neighbor by their actions, consider amending the PUD as the board has suggested. Obviously, that is something that the city councilman, who seems supportive of the idea, would need to do, but we believe that in accordance with what the planning department has said, it's an absolute bar to this board granting the request today. Thank you.
Okay. So there's a lot there. I'm going to try and keep this as brief as possible. And I have to go back to the PUD for a second. To me, I agree with Mr. Burgunder. This is pretty simple. You have a Section 3 that dictates all of the permitted conditional accessory uses as a whole in the PUD. And then you have A, which refers to uses on the first floor that would be allowed in an M1 district. You have B, which refers to other zoning districts. And as part of that Section B, in the first part, it says permitted uses, restaurants, but not including live entertainment and dancing. So that does not prohibit live entertainment and dancing throughout the rest of the PUD. And as an example, here's the list of land use classifications from the old zoning code. Restaurants, not including live entertainment and dancing, is a specific designated land use, just as restaurants, including live entertainment and dancing. I mean, they're apples and oranges, and saying you can't have one doesn't mean you can't have the other one. I mean, it's a pretty simple concept here. And as that referred to, restaurants, live entertainment, and dancing are a conditional use that are approval by the zoning board, both in those zoning districts and in this PUD. And to say the specific overrules the general, these are all the specific. In section 3, it dictates several different subsections that are all equal specifics. Not one is greater than the other one. And this is not something unique to this plan unit development. This is done in, I believe there's roughly 200 PUDs. I bet you could pick probably half of them, and they would have almost identical land use provisions set forth what's allowed in the PUD. And again, this is something that it is seen all the time. And in regards to just dropping this application, coming back and being a good neighbor, I can't see how, one, we have not been a good neighbor in this, and two, how that would do anything. I haven't heard any substantive opposition to this other than an opposition that goes through every document with a fine-tooth comb to find any little thing that's not correct with this. I mean, this is a sort of a living, moving application that is, as of last night, in our coordination with the Community Law Center and the new Green Mountain West Community Association, I think evidenced by the number of support letters and agreements we have, I'd urge the board to approve this appeal, and I absolutely think the board has the authority to do it, whether it goes to circuit court or not. That's not up to our control at this moment. But I think it's a great proposal. Again, we've got a lot of support. We'd love to continue to work with Mr. Burgunder and Mr. Linden. I think we can all agree on that. We love to continue to be good neighbors in this.
Let me ask a question. We typically don't go have a server rebuttal, but I want to ask a question of you with respect to your client. You mentioned there's a hardship to your client. What is that hardship?
If I could have Mr. Linden, as briefly as possible, address, I mean, they live next door.
Okay.
They're residents. They're residents, and it's going till midnight on a weekday. And at this point, because they aren't operating, it's impossible to know what the sound is going to be. And they don't know what the capacity is, so they don't know how many people are going to be in there. And so I think there are a lot of unknowns. And
There's also no parking plan that we know of.
That's not as convincing, Mr. Burgunder.
So in regards to the parking
appreciate that,
plan,
But if you live in the neighborhood, it's very convincing, because if you'll remember, we live very close to Penn Station.
I totally understand that, but Uber is a magical thing, and a lot of people use it when they're drinking.
That is true.
and we'd be happy to make the parking arrangement that was discussed at the beginning of this hearing part of the conditions, as it has been in the negotiation. The Community Law Center is quite good, and they don't allow their clients to enter into agreements like this without being fully vetted. And we've presented everything that they've asked for, and not to speak for Ms. Witt, but
No, it's clear that they support it, and they're excited about it.
yeah, thank you. And, again, we absolutely meet the conditional use standards for this, by the way. The conditional uses under state law are presumed to be permitted unless you can show there's a more adverse impact at the subject location than any other similarly zoned location. And this really would be the best location for live entertainment in this area. Not to mention, I think they all are, because you're in an arts and entertainment district, which was created by the city council in itself. You have walls that are thick enough to, and especially with the improvements, prevent sound from protruding onto the street into adjacent property owners. You have a big wide area, you have a large lot, and so I would argue that absolutely this is appropriate for this conditional use to be approved by the board.
All right.
Great.
Thank you all for your
Thank
presentation.
you very much.
When do you plan to open the restaurant and brewery?
So part of the, timing is that we were hoping to get open in March, but we have some utility upgrades that are taking some time. So we are now looking summertime. So we're looking between July, August, best case scenario right now for that. And, as for the sound and parking, our neighbors are a school, a church, the social services building. I mean, they really are our only living neighbors at this point. So, I mean, we are looking to be good neighbors to all of them.
Thanks so much.
Thank you.
Recall, this guy may be for the case.
Yeah,
Going to recall the case of 2019-384, 3507 Edmondson. Gregory Bennett? Okay, still not here.
He came in late, JC.
Okay, moving on, case number 2020-04, 6500 St. Helena Avenue, Valerie Burke. Do we have opposition as well?
I'm with the Community Association and we are for.
Oh,
Okay.
everybody's.
You're in support.
Yay.
Got it.
All right, good.
All right, thank you. Ms. Burke, this is a request to you, are you Ms. Burke?
Yes,
All right. The request to use premises as restaurant and carry out food shop, is that correct?
yes, we changed it to just a restaurant.
Okay, well, yes, you changed it. So, is this a request to use the premises as a restaurant and carry out food shop, or just a restaurant?
No, it's gonna be just a restaurant.
Okay.
I'm
Ms.
gonna
Wi-
explain because I was just told that you can't. Okay, thank you.
Yeah, well, I want to confirm, I'm looking at obviously what the application says. We'll address that. Could you swear the parties, please?
Raise your right hands. Please, do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
I do.
Okay, do we have any staff reports?
Yes. Planning Department reviewed this application, noted that this property qualifies to be a neighborhood commercial establishment in a residentially zoned area, the R6 zoning district. The neighborhood commercial establishment category does allow restaurants. It does not allow carry-out food shops. And for that reason, the department recommends approval of the portion of the application pertaining to a restaurant and disapproval of the portion of the application pertaining to a carry-out food shop. And that was because the zoning code authorizes approval of restaurants but not carry-out food shops as neighborhood commercial establishments. We met just before this hearing, and that is the reason that the applicant is now requesting an amendment of this application.
Very well, thank you, Mr. French. Ma'am, can you hear from you?
Yes.
Go ahead.
I purchased the building a long time ago, and it didn't become what it was supposed to be. We came to zoning before. So we came to the conclusion that we would like to open it up as a restaurant.
Okay.
What kind of food?
A home-cooked meal, so I'm gonna have a chef.
Estimated number of employees?
To start, maybe 6.
How many tables?
I believe right now, after we have to go back and get a new drawing to put in the kitchen, I would say 40 people.
And will it be a full commercial kitchen?
Yes.
Wait staff?
For now, friends and family.
Okay. Will food be served at tables?
Yes.
Okay. Thank you.
Anything else from the board? You wanted to
Yeah,
offer?
my name's Shirley Gregory. I'm the president of the St. Helena Community Association.
Yes, ma'am.
Originally, Valerie was trying to open it as a restaurant and a bar and has lost the liquor license. And it wasn't, I didn't even know that she couldn't do carry-out, to be honest with you, because the Community Association discussed it, and we were like, we have no problem with it because we're in a very isolated part of the community. There really isn't anything near us because of where we're at. We're right next to the Port of Baltimore. So it's like for me to go out for food, I really got to travel out somewhere. So it would be ideal for her to have food and even be able to carry it out. But they said no carry out, so I don't know if there's like wording that she needs to change that they can order
Well, she's amended the application.
to
It's only
take
a
out.
restaurant. so-
Yeah.
So just to clarify with the carry-out language, most restaurants can have carry-out services as part of a main restaurant. It just can't be the main business model. So just like most restaurants, you can call ahead and pick up food, but if you would go there, it's a full-scale restaurant. Most people are there seated for dining. So the original application said restaurant and carry-out. Our question was going to be, are they separate operations? So you have a main restaurant, then you have a little carry-out window? Or is it simply a restaurant that, you have the ability to call ahead and then pick up food? I don't believe planning would have any opposition, and the code does not have any prohibition on a standard restaurant use where you can call ahead and order food. But again, the main operation would have to be what most of us would think of as a restaurant. So
Yeah,
just to
well,
clarify that.
She actually has tables already set up inside.
Great.
It's actually, she put a lot of effort into the establishment, and I'd love to see her become more than what it is, of course, because it's empty and it is so close to the port, so it would be ideal for the port employees to come too, so,
Great, thank you.
yeah.
Got a great booster there.
Thank you.
Congratulations. All right. Anything else you'd like to add to your application?
No, that would be
All right,
it
very
for
well.
today.
Thank you for your presentation.
And thank you. Thank you.
Have a great day. Calling the case of 2020-14, 3801 Hillsdale Road, Janine Coates' house.
How y'all doing today?
Good afternoon. Ms. House, this is a request to erect 727 linear feet of 6-foot-high fence around the property. Is that correct?
Yes, sir, it is.
Okay. Could you swear the witness, please?
Raise your right hand. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, do we have any staff reports?
Planning Department has no comment on this application. Thank you.
Tell us about your project, Ms. House.
Basically, I've been running childcare for a long time now, and
I'm going to ask you to speak into the mic and
I
keep your voice up.
apologize.
It's all right.
I've been running childcare now for a very long time, and the building that I'm in now is at 3616 North Rogers Avenue, and it's small. So I'd like to say, first of all, thank you for giving me the extension for my application for 3801, because when I lost my husband, I didn't know that I had to get a certain time, to have my permit, and the young man told me what to do. But my goal is I have a lot of children who come in with disabilities. So when I purchased this property, I don't know if you've seen a picture of the property, but it's beautiful. And I want to be able to use my whole land of my property for my children. And I want to be able to make sure that my kids are safe at all times. Not only do I want to make sure that they're safe, like I said, I want to be able to have activities for them to use throughout the yard, not just one area of the yard.
How many children do you service? Can you turn that off
I'm sorry.
or silent?
Okay, thank you. I wanted to show you the
How many children do you service?
picture. For this building, you gave me 50.
50?
Yes.
Okay, what are the ages of those children?
From age 2 to school age.
Confirm for me what that means, 2 to school age, through what age?
Oh, I'm sorry, through age 12.
Age 12?
Yes. So you have to put in 2 different play areas because of the age.
Okay.
So because the yard is so huge, I want to be able to, utilize my space for, the younger ones and the older ones. So that way you can keep them in their areas, that way, everybody can have their space to play.
Okay. Currently, there's no fencing whatsoever around your property?
It was one there when I first bought the property. It was like a 3-foot fence. But when I had Maryland Decker come in to put the fence up, I thought they would do what they need to do. I didn't know they had to have a permit. I wasn't sure about that, but I left that up to them.
Okay. What kind of fence is it that you're having?
It's not a private fence. You actually look right through it. I don't want a private fence. It's a chain link fence.
And the fence goes around the entire perimeter of the property?
Yes, sir, it does.
And the properties, looks like everything else in this community is either single-family or multifamily housing, is that correct?
Yes, sir, it is.
And have you heard any complaints from your neighbors or opposition to either the
No,
daycare or
actually,
the fence?
they happy that I'm there.
Great.
And just to let you know, I found a piece of property that's located at 5504 John Crow Avenue that sits right across from a daycare center that has a 6-foot fence around it. And also that piece of property does too, and it's a corner lot.
All right. Any questions from the board? I'm good. All right. Anything else you'd like to add, ma'am?
Just want your approval, that's all.
All right. Thank you very much for your presentation.
Okay, thank you.
Calling the case of 2020-26, 1709 through 1717 Fleet Street. Step down. You know what? I'm going to skip them then. Is Ms. Williams present here? Okay, we're going to call 2020-27, 420 Esquith Street.
Wait, which one are you calling? Yeah.
And I'm going to call the second matter as well involving you all. Case number 2020-28, 500 North Central Avenue. And for the record, case number 2020-27, 420 Asquith Street. This is a request to construct a four-story multi-family dwelling, 72 dwelling units, 18 market rate units, and 15 affordable rate units with 41 off-street parking spaces and 45 square foot projecting sign. Is that correct?
Yes.
And for matter number 2020-28, 500 North Central Avenue, it's a request to subdivide the lot and construct a five-story mixed-use building, 197 dwelling units, including 36 market rate units and 161 affordable rate units with 2,450 square feet of ground floor retail, including outdoor dining and 89 off-street parking spaces. Is that correct?
Yes, and that one I also want to update. In my summary write-up, there's also a 33 square foot maximum projecting sign for this building.
33 square foot sign. The first one had 45 square foot. This one's 33.
Correct.
Okay.
So it's amending the application to include a sign area
Yeah.
size variance for the
Got it.
second appeal.
Very well. Okay. Just swear the witnesses, please.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Do we have any staff reports?
Yes, Planning Department has reviewed each of these applications concerning appeal number 2020-27 for 420 North Asquith Street. The department is recommending approval of this application, subject to the condition that all construction and improvements, related landscaping, and so on are completed and installed in accordance with plans approved by the Department of Planning. There has been a long and ongoing planning process involved with this particular property. With regard to appeal number 2020-28 for the property to be known as 520 Somerset Street, there is a portion of this application that the Planning Department is recommending a disapproval of, and that is the outdoor dining or outdoor table service component. The rest of the application, the department is very much in favor of, subject to the conditions as expressed previously. Construction and improvements, including structures, landscaping, and signage, are completed or installed in accordance with subdivision plans and development plans approved by the Planning Commission. That is because this property is going to be created by subdivision out of a larger lot, currently known as 500 North Central Avenue. The outdoor dining is an item which is in the zoning code, in the R10 zoning district where this site is located, not permitted, and therefore the department is recommending disapproval of this particular piece of this application. Thank you.
Thank you, Mr. French. Ma'am, tell us about your project, but if we could start with the
Sure.
outdoor dining issue.
So
in
I'll
2020.
I'll start with the second application for 520 Somerset Street,
Yes,
which
ma'am.
will be the new address, which has already been approved by property locations. And this would be the second building in the Somerset Master Plan. The city is going through a comprehensive neighborhood, choice neighborhood plan for Perkins, Somerset, and Old Town Mall area. Somerset is the first of those projects. This is the former Somerset Public Housing site. The board has already approved the first project, 1234 McKeldery Street, which runs on the northern section of the site and is in the master plan that was provided to you, and we obtained approval for that particular project for multifamily dwellings, for a small bit of retail and outdoor table service for that building. This is the second building, the 520 building. It is again for 197 dwelling units maximum with a small, under 25,000, 2,450 square foot commercial space and off-street parking under the building. For the oops. Just trying to find my summary. For the variance for this particular project, we're looking for a rear yard setback, maximum lot coverage, parking, the identification or blade sign, and the outdoor dining as an accessory use. We've been through, in terms of all but the outdoor dining, we've been through site plan review, we've completed all our forest conservation, we're working on all our stormwater management, and have been approved by UDAP as well. So this has been vetted through a fairly detailed design. For the outdoor dining service, we would like it just as we got it for 1234 McKelderry. These are areas where you have, if you look at the master plan, you have a block square parcel. So it's a fairly unique situation. I don't think most of the R10 is located up around University and Charles, and it's a slightly different area. This one is a little unique. All of the buildings that we're proposing for the first 3 buildings face an open space that we'll be creating that's a block big, and the idea is to have an activated streetscape around that block. So on these 2 buildings, the 1, 2, 3, 4 you already approved, and this one, we're looking at allowing whatever tenant would be there to be able to put a chair or 2 outside. If it's not something the board deems appropriate, we'll accept that, but it's something that we would like.
And it may be something that we don't have any discretion on.
Yeah, yes, sir. I don't know if you have any questions about that parcel. The other project is located on Asquith Street. It's actually shown as S4 on the master plan. The master plan was written and numbered before we actually started sequencing and implementing. This building will be totally residential. It'll be 72 multifamily units and 41 garage spaces. This project has also been through site plan review and approved by site plan review, and it has been through UDAP. You can see that it is currently an unused or underutilized parking lot that was part of the Old Town Mall. It's in the Old Town Mall urban renewal area. It's a disposition lot in that area that calls for housing. And our requests are for a rear and interior side yard setback, parking, and the increased size for the identification or blade sign. And the applicants, which include the Henson Company Corporation, Henson Development Dan's company, and also Mission First Housing, which is a group that works to provide housing for all income groups.
Terrific.
And I'm happy to answer any questions, and the applicant is here as well.
Okay. Just one question for Mr. French and Mr. Baumgartner. The prior approval for the McElderry property, is that also R10?
Yes.
I don't know.
Yes, it's R10.
I can't recall off the top of my head. I would defer to Ms. Williams on that one. But I can't, other than the project generally, I can't recall the specifics. And if the chairman's going towards the question I think he's going to with outdoor dining, I have a similar question with Somerset that for all practical purposes, the development with outdoor dining would make sense. However, is there a way to get the accessory use for dining that would not be prohibited under the current code? Or I can ask it this way. What would it be accessory to?
The retail.
What type of retail?
We don't have a tenant right now.
Right.
Sure. And I guess that's what I'm struggling with. If outdoor dining is simply not allowed, then it's being requested as accessory to something. We just don't know what that something might be.
It's to the retail space, but not specific.
Sure.
I mean, and if it means when we get a tenant and we have something that,
And
You know,
certainly come back and
yeah.
visit us and
yeah, we
seek to
can
upgrade
certainly
that.
revisit it. But in some of the other areas of the city, and I believe like the Ambassador maybe R10, that they've had outdoor dining in their back garden since I was a kid. You know, so it predated the code, but it's not something that's inconsistent.
And I think the intent or, outdoor dining under the code has a very specific use, meaning that, you have folks who are being served food and drinks. It's not necessarily to prohibit tables for, use.
Mhm.
So you could potentially have tables in any kind of common use area or common area that folks could bring their own food or sit out there and play cards or chess or anything else. And I don't believe that would require any further review or permits by this board or any other reviewing agency. It just simply as far as I know, it simply couldn't be accessory to like a restaurant use where you're serving folks and you have.
So
folks
if somebody
coming
picked up a sandwich and walked
Exactly
outside
right.
versus the waiters being out there.
in this wonderful country we live in, I think you could do that by right anywhere that you wish, and you could certainly provide those tables so that folks could do that, and I don't think that would require
Wi-Fi
additional-
hotspot.
Exactly. Right. So just food for
That's
thought.
helpful, thank you very much.
Okay, is there anything you'd like to add at this point? Okay, any further questions from the board? Nope. All right, thank you so much for your presentation.
Thank you very
Thank
much.
you very much.
Maybe called my name when I was on.
We did call your name.
Yeah, we did, we
Sneak
did.
back in.
Sure, let's do this.
You again?
Tell me about it.
Call the matter of 2020-26, 1709 through 1717 Fleet Street. Mr. Prettle.
Good afternoon.
Good afternoon, sir. This is a request to consolidate 1709 through 1717 and 1719 Fleet Streets and construct third and fourth floor additions to use premises as 23 dwelling units with first floor commercial space.
That's correct.
Swear the witness, please.
He's already sworn.
Oh, you're sworn.
I hope so by now.
This guy, I think you ought
Yeah.
to swear him 3 or 4. No, all right, we're good. Staff reports, please.
Thank you. Planning Department reviewed this application, noted that this property is in the Fells Point Historic District, also the Chesapeake Bay Critical Area. Specifically speaking to the Historic District, there is a requirement that any alteration to property, new construction, et cetera, be approved through an authorization to proceed issued by the Commission for Historical and Architectural Preservation. That ATP was issued on January 29th of this year. The department therefore recommends that approval of the application be subject to the conditions that the proposed multifamily dwelling and improved street-level commercial space be constructed and completed in accordance with the authorization to proceed issued by the Commission for Historical and Architectural Preservation, and that all new construction and alterations are completed in accordance with plans approved by the Department of Planning, a reference to the critical area. Thank you.
Thank you, Mr. French. Mr. Prettle, should we be favorably disposed towards your application? Are those conditions acceptable to your client?
Absolutely.
Tell us about your project, sir.
So in relation to CHAP, not only are those acceptable, as I mean, this project has already been through a significant, not only community and community design review committee process, but we already have obtained CHAP concept approval for the height, scale, and massing of the proposed addition, CHAP being the city's Commission for Historical and Architectural Preservation, as well as final design approval, both I think in the summer and fall of 2019. You know, and at the time, it was looking like this was a project that did not have to go to the zoning board. The zoning administrator, we're not increasing or decreasing the rear yard setbacks, just building on top of existing setbacks. And there's some miscommunication, but when it came down to building permit, they said, well, no, you know, go to the board for a rear yard setback. I mean, this is a absolutely unique property. The main structure was built as a church, and then later became, and most recently, a liquor store, into a very large liquor store until it burned maybe 6-7 years ago. I don't remember the exact date. It's been sitting vacant since then. There's the rear building on the other side was a school, but it's all vacant right now, and a really significant site in Fells Point, just east of Broadway, you know, on the south side of Fleet Street. And the client in this situation is Brandon Chasin of Chasin Construction and Development, and their firm is doing a number of sort of adaptive reuse / historic preservation projects, both one across the street from this, several on Eastern Avenue, and really established a great relationship with the community as well as the city's Architectural Review Commission. And you know, we look forward to this being another asset to the Fells Point community. This will be a multifamily project. We're here for variance for bicycle parking, which is not initially what it was flagged for at zoning. It was a rear yard variance. But yeah, I would be happy to answer any questions, and you'd urge the board to support this.
Questions from the board?
I'm good.
Okay. Okay. If there's nothing else, thank you for your presentation.
Thank
Mr.
you.
Ritter. I'm going to call this other case one more time, then I'll leave it. 2019-384, 3507 Edmondson Avenue. Gregory Bennett. Okay. So Bennett's a no-show, so we're good now. Calling the matter of 2020-30, I'm sorry, 2020-29, 2423 Reisterstown Road, Eleanor Williams.
Good afternoon.
Good afternoon, Ms. Williams.
And this is my partner, Ms. Janella Jennings L.
Okay, this is a request to use the first floor front, known as 2423 Reisterstown Road, as a restaurant. Is that correct?
That's correct.
All right, can we swear the parties, please?
Yes, raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, do we have any staff reports?
Yes, Planning Department reviewed the application, noted that the board had previously approved this property for retail sales and party equipment rental on May 29th of 2019. The department has no objection to the application and believes the applicant should clarify whether this proposed use, which is a restaurant, would supersede the previously approved neighborhood commercial establishment uses or be in addition to one or more of them. Thank you.
Okay. Ms. Williams, particularly in reference to Mr. French's question, is this now a new and sort of exclusive restaurant, or is it going to operate in conjunction with prior uses?
It's going to, in conjunction with the previous.
And to follow up, what is the property currently being used for?
Right now, we rent like tables and chairs. So that's what we're doing right now.
And have you obtained any of the use and occupancy permits for that structure?
That's in the making.
Okay. Because I just noticed that there's a lot of uses that are requested, some of which might be by right, some of which the board has previously approved, but as far as I can tell, there are no current use and occupancy permits that have been issued. So it would be important to get that use and occupancy permit before you open up a business. Otherwise, housing could come out and cite you $500 a day.
I understand.
Okay. All right. Are there any questions from the board?
I don't have any.
None? Anna, you good?
I'm good.
All right. Is there anything else you'd like to add to your application?
I do have letters from the community.
Great. Who's handing
And I
them out?
also have a letter from Councilman Pinkett III.
I assume all in support of your project?
Correct.
All right.
I'm sorry.
We'll make these a part of the record
Yes.
again for quite a few.
And I also would like to say, we're planning to open a soul food restaurant at that location. There is no other restaurants in the area except for TGI Friday, which is at Mondawmin Mall. There's a lot of elderly people that walk around and, that don't have transportation where we would be of access to them. There's also opportunity for us to employ some students where you have Douglas High School, which is, in the neighborhood, as well as far as employment. I also would like to give back to the community because I also was raised in that area. So that's my way of giving back to the community as well. So, and there's also, it would be, like I said, with the elderly, it would be something nutrition for them to, have to eat, except for there was a carry out like about 4 doors down that is now closed. So now they don't even have that to go to where I just see, we used to see a lot of people going there. But that leaves no place now, in that area for them to get nutrition.
And
Go ahead.
I was going to say, in this particular space, is the commercial kitchen there already, or are you going to put that in?
We will put it in.
And then this specific tenant space, what was it used for prior, if you know?
Well, it was a daycare center from what I understand.
Okay.
Is yours the corner?
Yes, on the corner of Bryant Avenue and Reisterstown Road. I think there's a barber shop that's like adjacent to us on Bryant.
So, is Bryant like an alley?
No, it's a street.
Okay.
Now there, as we know, Mr. Bungalow, there's a distinction between carryout and a restaurant. Correct. Different requirements. This is a restaurant as opposed to a carryout?
Yes, because we were we were told before that that zone or whatever the number is carryout was not acceptable, but I could do a restaurant in that location.
Okay. The reason I ask is some of these support letters.
A lot of them, yes, because they,
Just so
exactly.
the record's clear, they reference-
Yes, exactly.
Just for the record, they reference a carry-out
Yes,
and take
on
out.
some of them, correct.
So you will have seating.
Yes.
Do you have a sense of how many seats would be available in your restaurant at any one time?
We're looking at 30 to 40.
Okay. All right. Okay. All right. Thank you for your presentation.
Thank you so much.
Good luck.
Thank you.
Okay.
Ms. Coates' house again.
I'm sorry?
We have the same, Ms. Coates' house.
Yes. She's here for two.
Yeah, okay. 2020-34, 3616 North Rogers Avenue. Ms. Coates' house?
Welcome
Welcome
back.
back. This is a request to increase the existing 24-child daycare to 28 children. Is that
Yes,
correct?
sir, it is.
You're already sworn. Do we have any staff reports?
Yes, Planning Department has reviewed this application and has no objection to its approval. Thank you.
Okay. The basis for your request to increase the number of
Well,
children?
the basis was that I want to take my toddler classroom for 2-year-olds and turn it over to an infant classroom. So for me to do that, OCC stated that I need to have zoning to change the number on my permit because it said 24. So that's the purpose for it. Since I'm going to be moving over to 3801 with all the toddlers, I was going to have 2 infant rooms at 3616 to kind of like keep the revenue going for both locations.
Understood, understood. Okay. Any questions from the board? I'm good.
No questions.
I have one question. How close are the houses to each other?
I'm not good with this, but I'm going to say 3616 sits on Rogers. If you leave out the front door, you go down 5 blocks and go over 4 blocks.
Okay.
Yes, ma'am.
And you obviously have staff at both of these. It's
Oh,
not
yes, I
just
have
you.
12 staff members.
Okay.
Absolutely.
Very good.
Yes.
Thank you for your presentation, ma'am.
Okay, thank you.
Good luck to you.
All right.
Yeah, who's here for that? Okay, 2020-35, 4015 Foster Avenue. Mobtown Brewing Company LLC.
She can pick out the brewers.
Sure can.
Again. Good afternoon, gentlemen. This is a what's your name?
I'm Noah Chadwick.
Okay, gentlemen, this is a request to add live entertainment to the existing brewery and tavern.
Yes, sir.
All right. Could you swear the parties, please?
Raise your hands. Right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
You said David Carpenter? Yes.
Do we have any staff reports?
Yes. First, I have a letter from the Brewers Hill Neighborhood Incorporated. They write that they are in support of Mobtown Brewing obtaining their permit for their live entertainment. The association supports their application to hold live events within their tap room, not to extend past the business hours of 9 p.m. on any given night in the brewery is open. Live entertainment will not only take place within the brewery unless specified by a special city permit that allows outdoor entertainment for a block party style event.
Planning Department reviewed this application, noted that this property is located in the I-1 zoning district. In this particular zoning district, although the tavern may be permitted, the proposed live entertainment accessory to the tavern is not authorized by the zoning code. The Department of Planning therefore recommends disapproval of the application because the board is not authorized to approve live entertainment, whether as a principal use or as an accessory use, in the I-1 zoning district where the property is located. The department further notes that this provision of the zoning code may become inapplicable to this property if it is included in a possible comprehensive rezoning of the northern part of the Canton industrial area. Thank you.
Gentlemen.
Sir,
can you-
so we would like to request postponement of the remainder of the hearing and possible decision based on the information that we received from the planning department. We were aware that there was the possibility of rezoning, but that was being proposed by others that after we had put this application in, it says I was CC'd on the bottom. I just got this today.
Okay.
So if we could postpone this to a later date, we could speak with the planning department on when would be appropriate. We would very much appreciate that.
Mr. French, just real quick, has there been any legislation that you're aware of that might rezone these properties, or is this something that's been in discussion?
I believe it's in discussion. I don't believe there's any introduction of legislation yet.
Talk to your councilperson.
Yeah, and I've read the description of both I-1 and IMU-1, and we feel that we're definitely more the IMU-2 than we are I-1. Specifically our building, but also our neighboring buildings, so we will go that route and hopefully see you again.
I would offer the board just the editorial comment that the board has routinely heard applications when there is a rezoning pending, so that you wouldn't necessarily have to wait until that rezoning goes all the way through the process.
Sure.
We generally don't hold a hearing pending something that might never come to fruition. But if there is a bill pending before City Council, the board has traditionally taken matters back up before that bill is passed. So I just offer that as a small editorial comment regarding the rezoning of properties that might make the use.
Are you involved in the discussions that were referenced? For the zoning?
Barely. We were told about it by our landlord after we submitted this application. So I think there's
It would be the community planner and other people involved in this.
Go ahead, Councilman.
Will do.
How long can we postpone a matter?
1 year?
The board generally goes back through postponed cases 12 months after they've been postponed, and then kind of, I call it, purges the files. So we generally hold matters for 12 months. That's not a rule, that's just past
And
practice.
they can ask at any time to have it set back.
That's
in
correct.
if something happens before that.
That's
Then
correct.
we just requested a hearing.
All right.
Okay.
All right, well, we've
I
heard
consent to a postponement.
I consent.
postponement granted.
Great. Thank you very much.
All right, good luck to you.
Take care.
Sure.
That is the, let me do this one more time.
Do it.
One more time. Case number 2019-439, nope, sorry. Case number 2019-384, 3507 Edmondson Avenue. Gregory Bennett. Gregory Bennett, once, twice, 30 times.
I don't think he's gonna show up.
All right. No show. That's the docket?
That's the
Mr. Chairman, I would, it's certainly up to the chair's discretion, but I'd recommend that the board deliberate on today's docket, and then we take a brief 5-minute recess, reconvene for the Boston Street appeals. I disseminated copies of the post-hearing memoranda from both parties a week or two ago.
Yes, sir.
And then again earlier this afternoon. So again, just to get the folks out the door that have been here all day, and then we can reconvene and deliberate and vote on Boston Street if that's the chairman's choice.
I'd say we do that. We'll go ahead and deal with the regular docket and then come back for Boston Street.